Good morning, and thank you to everyone for taking the time to join me on your Thursday morning. My name is Alasdair Dick, and I've recently joined Mills Reeve to help expand our complex coverage offering for insurers, with a particular focus on claims made against directors and officers. Before I get going, there are, as usual, a couple of housekeeping points to run. The session will last for about 15 to 20 minutes, with a little time left over for questions and answers at the end. My colleague and senior legal advisor, Harriet Strevens, will marshal these for me in the interim. So if you have any questions, please post them in the box below. If I can't deal with them today, or if there's anything we've covered a bit too quickly because we're going through it a bit of a canter, I will do my best to do so in an email following the session. So let's get going. We are going to look at primarily the case of BTI and Sequana, which considered in detail how the duty directors owe to company creditors operates. We need to understand how that judgment impacts upon insurers, mainly in relation to the scope of claims which attach D&O policies. Equally, it's important to understand how it operates with the alternative remedies available to creditors under the Insolvency Act. Primarily, the remedies of wrongful trading under Section 214 and preference under 239. So, first, we need to have a brief look at the issues which built up to the decision itself to understand how Sequana and now Hunt have changed the current landscape, assuming they really have. So when we're looking at the fiduciary duties owed by a director, starting from basics, what do we mean? The commercial rationale behind allowing individuals to incorporate companies has always been that it permits them to invest their resources in potentially high-risk corporate ventures, but limit the downside risk if the risks really bite. As a consequence, it accepts that the individuals who will run and manage the business are unlikely to be the same individuals who own the assets in the company or are beneficially owners of the company. In light of that responsibility, the laws always imposed a fiduciary duty on those directors to act solely in the best interest of the company. And that's been the key. Over the years, the interests of the company have been understood to mean the best interest of the shareholders or the individuals who beneficially own the assets of the company, which the directors are entrusted to manage. However, the question has become, to whom do directors owe those duties when the company is failing? Helpfully for us, the answer was originally provided back in 1986 in West Mercia and Dodd. Having a look at that case, Mr. Dodd ran a company called West Mercia Safetyware, alongside his imaginatively named company AJ Dodd & Co Limited. Both companies traded between themselves, and West Mercia ended up owing Dodd & Co over £30,000. Neither company did particularly well, and Mr. Dodd was told by his accountant that both companies were insolvent and he shouldn't touch the funds in either account any further. The difficulty for Mr. Dodd was that while West Mercia still had some funds, the Dodd & Co account was overdrawn by £4,000. That was particularly troubling for Mr. Dodd because he personally guaranteed that overdraft. So, as West Mercia owed over £30,000 to Dodd & Co, Mr. Dodd used some of the funds available to pay off the £4,000 debt, conveniently extinguishing his own personal liability. The West Mercia liquidator was not impressed. He didn't accept that Mr. Dodd was entitled to transfer funds from one company to another, not least as he'd been told not to touch them. There was, however, a challenge for the liquidator. The money was properly due to Dodd & Co. In fact, it was only a small portion of the debt. So paying the debt itself was not improper and was arguably in line with Mr. Dodd's duties as a director. The liquidator could have sought to recover the funds from Dodd & Co. on the basis it was a fraudulent payment, and that Dodd had no funds to repay any amount which was ordered. The liquidator therefore chose to go after Mr. Dodd directly, avoiding the fraudulent preference and alleging instead breach of fiduciary duty and paying out sums to one creditor at expense of the general body of creditors. The Court of Appeal agreed. They found that as the company was insolvent and Mr. Dodd had been told not to trade from its accounts, there was blatant wrongdoing and a breach of Mr. Dodd's fiduciary duties to the creditors as a whole. He was obliged to repay the £4,000 along with interest, and in doing so, established the rule in West Mercia, which we have applied for approximately the last 40 years. That rule approved a previous Australian judgment and has over the years come to dictate that, as shown on the slide, When a company is insolvent or insolvency is imminent, a director's duties extend from simply acting in the best interest of the company through its shareholders to acting in the interest of shareholders and the general body of creditors. So that leaves us with two questions. First, when is insolvency inevitable? And second, how do you balance the interest of shareholders and creditors? The when has been argued about over a number of years with a lot of different interpretations. The how was helpfully set out by Parliament in an extensive piece of legislation in 2006 in the Companies Act. It gave us sections 171 to 177, which, as you'll see, set out the 7 general duties of directors and how we expect them to act. I won't read those out today, as we are only concerned with the duty under section 172 to promote the success of the company. Ironically, section 172.1 makes no direct reference to creditors when it sets out the matters to which a director must have regard when promoting the success of the company. However, the Act is subject to a caveat in section 172.3, which amends the duty to be as illustrated on the slide, to be subject to any enactment or rule of law requiring directors in certain circumstances to consider or act in the interest of creditors of the company. Now, the court in Sequana specifically confirmed that it accepted that caveat was intended to include the rule in West Mercia. So, 20 years on, notwithstanding the legislation, we're still faced with the same question the court looked at all those years ago, i.e. the when and the how. When is insolvency inevitable? How do you balance the interest of shareholders and creditors? Those were the principal questions addressed by the Supreme Court in Sequana. So let's look at that case. Sequana owned a company called AWA. AWA was liable for cleanup costs following the pollution of the Fox River in Wisconsin. As with Dodd, AWA had made various provisions in its accounts to cover those costs. If the actual costs of the cleanup were lower, the company would have remained solvent, and in any case, there was no risk of imminent insolvency. Again, like Dodd, each company owed the other a debt, and the subsidiary, AWA, chose to issue a dividend to clear its liability to Sequana. At the time, there was no suggestion from either party the dividend was unlawful, and in fact, AWA remained solvent for a further 10 years. As matters transpired, the liabilities, which had been guaranteed in this case by BTI, were considerably greater than AWA's provisions to pay them. The liabilities, which ultimately resulted in the company liquidation, existed at a time when the dividend was paid, and there was therefore a real risk of insolvency if the contingent liabilities crystallized. Thus, the question posed to the court was it a breach of the director's duties to creditors to agree to make payment in the first place? The court said no. Simply facing a real risk of insolvency was insufficient. The company must be or be on the verge of insolvency, and whilst they recognized that was difficult to pinpoint, they decided there was a sliding scale. The more parlous the company's financial position, the greater the importance which the director must give to the interests of creditors. This was excellent news from the Supreme Court for directors and for those who insure them. Sequana gave us some clarity around the timing at which directors must start to give weight to creditors' interests. All of that was looking good. In August this year, we had the first High Court case to apply that decision. Hunt and Singh came out in August, and if we look at that, in Hunt and Singh, a company had been running a tax avoidance scheme to minimize tax liabilities on directors' bonuses. The revenue disagreed the scheme was effective, and they served notice saying that the tax was due. Notice which the company challenged. In the absence of any contrary view, and I think it's important to know that the directors didn't put forward any submissions, it was only the liquidator that was represented in the trial. The court accepted, though, that the liquidator's position was, if the tax was due, the company was insolvent. You might think, similar position to Sequana, there is a liability which, if it lands, will render the company insolvent. Equally, you might think that the court would agree the duty wouldn't bite until it was clear if the liability was to crystallize. Unfortunately, the court didn't agree. It held that a liability, although challenged, was not a contingent liability. And the fact that the company did not accept the tax was due did nothing to change that position. It therefore ordered the directors were liable to take creditors' interest into account from the time they were served with the revenue notice. So where does that leave us? As ever, facing a very fact-specific position. It seems that if there is an assertion of a liability which would render the company insolvent, the courts will distinguish the contingent liability in sequana and hold the directors liable for their actions. So let's look now at how that position sits with the existing statutory remedies under sections 214 and 239 of the Insolvency Act. The true answer seems to be that the rule in West Mercia, and now established beyond doubt by the Supreme Court, sits in the grey area before a company becomes insolvent. The obligations under sections 214 and 239 of the Insolvency Act are severe. Under 214, if there is knowledge and no prospect of avoiding an insolvent liquidation, the director must act in a way which minimises the potential loss to creditors. West Mercia and now sequana, however, operate on a basis where the company is simply insolvent or on the verge of insolvency. Now, the meaning of insolvent still remains fact-specific, and there are discussions about whether it's commercially insolvent or balance sheet insolvent, as does the point at which the company actually becomes insolvent. There is no suggestion that every company which is insolvent will necessarily go into liquidation or administration. Some trade out of insolvency, some reach agreements with their creditors, and some can diversify or undertake successful commercial transactions which relieve the financial pressure. In any of those instances, creditors would have no recourse under sections 214 or 239 of the Insolvency Act. However, the case law now requires that as the company moves closer to becoming insolvent, the director must give more weight to the consideration of creditors' interests. The danger zone we've got on the slide is the problem area for directors, and it's the area at which they should start to consider who they are taking into account when they're making decisions. There are also important differences between the existing remedies under the Insolvency Act, which employs an objective test, as opposed to the subjective test under the credit duty when the director is considering their options. And that's got to be a good thing for directors because it's much easier to justify your decisions. However, unlike the remedy for wrongful trading, while your duties are still only owed to the company and not creditors, a claim for the breach of directors' fiduciary duty to consider the interests of its creditors can be brought by a much wider range of individuals than only the liquidator under the Insolvency Act. The key difference in relation to the protection for preference under 239 is that the remedy under the Insolvency Act was aimed at recovering funds from the entity to which it was paid. Claim for breach of fiduciary duty allows the court to order directors to repay those funds. And while that may seem like a minor difference, unless you're the insurer of directors, as Mr. Dodd found out, when the company that received the money itself is insolvent, it allows creditors to seek to go after you personally. So, what do we take away from the judgments? What's changed for directors, officers, and their insurers? One might say not a great deal from Sequana and Hunt. On the plus side, the court was very clear that a real and not remote risk of insolvency is not sufficient to trigger the West Mercia duty. Although, as we may come back to later, the courts have now managed to blur that very clear line. But for present purposes, the Supreme Court decision is the company must either be insolvent or on the verge of insolvency. Beyond that, the judgments practically do little to advance the position other than to confirm the validity and continued importance of the rule in West Mercia. As a company falls closer to the brink of insolvency, a director must give more weight to the interest of its creditors. What constitutes imminent insolvency remains fact-specific and will be decided by the courts on each occasion. On one end of the spectrum, if you're like Mr. Dodd and you've been told your companies are insolvent and not to trade from their accounts, the court's likely to find the duties triggered. On the other, if you're in the position of AWA and you're able to continue to trade solvently for a further 10 years, the court's unlikely to agree the duties triggered. How the courts will apply the countless situations in between those extremes remains to be seen on a case-by-case basis. The court's commentary appears to be that it will simply impose a more stringent duty the closer the company becomes to becoming incapable of meeting its debts as they fall due. How the director weighs the competing shareholder creditor interests remains a subjective test that the courts will have to consider on each occasion. It seems likely to us that directors will often be able to justify their decisions, but that will need to be without the aid of hindsight and, if possible, supported by contemporaneous documentation and detailed board notes. The courts have been prepared to say that, on one hand, selling a company at an accepted undervalue was not a breach of the director's duties because they thought it was the only way to keep the company trading and to pay its creditors. On the other, the courts have accepted that not paying creditors, with a view to enabling the company to continue to trade and to rebuild, was also not a breach of the director's duties. What is clear is that selling a cow for a last-minute bag of magical beans is likely to be found to have breached directors' fiduciary duties to creditors. What those interests are still remains elusive, and the courts have still not been prepared to definitively comment. You can see how situations could occur where it's in the interest of secured creditors for a company to cease trading where they would recover their debts. But in the same scenario, it would be in the interest of unsecured creditors who weigh in further down the pecking order for the company to attempt to trade out of insolvency so that their debts, which would otherwise be unsatisfied, might be met. On each of those issues, the court will have to consider the matters on the facts of each company, each transaction, and each decision of the directors. The upshot of the recent decisions, however, is that the scope of claims which may attach to D&O policies is almost certainly increased. That's the case both because of the increased scope of the potential liabilities on directors and because, arguably, the Sequana decision means that any breach of a fiduciary duty can now also be considered a breach of the director's statutory duties under 172 to promote the success of the company. And as a consequence, that might result in wordings responding to claims for breach of statutory duty, which might not previously have been triggered. Having taken up a good chunk of your morning, that's where we'll stop for now. I see we've had some activity in the question box, so I hand over to Harriet, who's been marshalling those questions.
Thank you very much, Alasdair. The first question I'd like to ask you is that you said that we'd come back to the courts blurring the lines on the test, not being that there is a real prospect of insolvency. I assume that's the Hunt decision, the questioner asks. Do you think it's a reliable decision, though?
I think we need to approach the Hunt decision with some caution. The court accepted it had only had submissions on behalf of the liquidator. The only remaining defendant director had already become personally bankrupt and so made no representations. I think there's potentially valuable insight to be taken from the fact that courts are prepared to draw a distinction between contingent and actual but disputed liabilities. But the test for whether those liabilities will bite, which the court in Hunt said was a real prospect of losing, accepts a test which, in essence, directly was rejected by the Supreme Court, which the judge himself even said. And also, given the remaining director was bankrupt, the issues arising from whether he was in breach of his duties hasn't been explored any further, and nor was anyone in a position to consider appealing the judgment. So while there are valuable points to take from it, I would be cautious relying on the judgment as a whole.
Yeah, fair enough. But how about the director's position? How do you think directors are going to have to balance their duty to mitigate losses in respect of potential claims against insurers when faced with uncertain limits on their recoveries?
I think that is a very good and potentially very wide and very fact-specific question. I think the overall answer is that the court in Hunt has now suggested that relying on professional advice, however strong that advice is not sufficient in and of itself to protect directors. And while the facts behind any challenge to insurers will undoubtedly be paramount and it will be subjective based on each director's decision, I would have thought the safer option for directors who don't have absolute certainty there is a solid recovery with sufficient limits to add to any creditor pot would be to protect the remaining assets available to creditors and not to embark on any potentially uncertain litigation.
I suppose with a slight wry eye, one might think it's better not to be a director in those circumstances. It's a difficult decision to make.
Yeah, they're all difficult decisions, I think.
I think that's right. Well, we've come to the end of our time for the time being. So if I may, I'll pass the baton back to you. And please, if you'd like to sew up, that would be great.
Thank you for that, Harriet. So our next session will be on the 5th of October, when my colleagues Ben Hardiman and Alana Williams will be providing you with an update on business interruption claims. We hope you'll join us again, same time, same place.